there. Welcome to Wellness and Care by Lori. And I just want to take a moment to thank you subscribers and new subscribers for coming into this channel. I so appreciate the support. And I'm very excited today because we are talking to Miss Diane Geller, a lawyer venturing, well, let me just tell you, we're venturing into business wellness today. And Diane J. Geller is a business and HR attorney at Fox and Rothschild in Palm Beach. So, Diane, thank you for being with us today.
Oh, it's my pleasure.
I really appreciate it. I really appreciate it. So, first off, before we get into any questions, I just want you to define your position as an HR attorney. So,
okay, well,
it's a big deal.
That's kind of a hard question to answer. So, I represent employers primarily in terms of dealing with human resource issues. Their employees, it could be anything from advice on hiring, firing, severance, employment agreements, non-compete agreements, confidentiality agreements, all of the above. But very much what I do is I'm a business counselor to my clients. And the reason why I say that is that I come from a background of being an in-house lawyer during the beginning of my career, a good portion of the beginning of my career. And what that did for me was that it gave me some special knowledge that most lawyers don't experience what really happens in corporations. Okay. So I bring that special knowledge with me.
Which is fantastic, but I want to also venture into this. I was doing some reading about HR attorneys. Okay. Today, I think there's so much going on with discrimination and laws. I know in 1964 there was a law against discriminatory
the Civil Rights Act.
Yes, Civil Rights Act and certain other. Has it changed? I mean, I know you've been doing this. Okay, so how long, first off, have you been doing this?
I'm not admitting how long I've been doing
it. Oh gosh.
I've been doing it for a long time.
A long time. So can you tell me that it has changed a little bit over the years?
It's changed a lot over the years. Okay. And so much of it, items have changed as to what are now considered discriminatory. Mm-hmm. For instance, gender and gender preference never used to be considered part of that Civil Rights Act. Sexual orientation was not part of the Civil Rights Act, and all of that is now part of
age.
Consideration. Well, age too. Well, age also has its own special act called the Age Discrimination and Employment Act, and it cuts in at 40 years old, which everybody thinks, wow, that's pretty young to have an age discrimination, but it was passed for people 40 and over. When the courts and the EEOC look at it, and plaintiffs' lawyers, they do look at people in tranches. So they may not look at 40 the same way they look at 60.
Right.
So all of that becomes, part of what happens when somebody files an Age Discrimination Act claim.
And it's interesting, I know today I had a friend who was at a bank, and the person who was employed by the bank was talking about how his wife is having a baby and how she's able to have all this time allotted. That, I remember, that was a sticky situation. When was the amount of time that you allowed that a female who was pregnant to have her baby, and now also her husband can get time off?
Right, correct? Well, you've got a couple of different acts involved there.
Is this new?
Well, it's been around for a while.
Yes.
The way it's interpreted has changed over the years. Mm-hmm. There's a Pregnancy Discrimination Act, which means that a pregnant woman that's having some medical issues related to the pregnancy is entitled to be treated the same way as somebody who just had a heart attack, for instance. Wow. So if you are going to give that person time off to recover from their heart attack, then you've got to treat that pregnant woman who's having a medical issue the same way.
That's fantastic.
And the other act that you're talking about is the Family Medical Leave Act. And that's been around for a number of years now, but it continues also to morph to where spouses that are not the delivery person, so it could be, even in same-sex issues, the spouse can get additional time off in order to bond with the child.
That's really
So there's a lot of really good things that have happened, but it's become very challenging for employers. It also, the federal act only cuts in at 50 employees. So small employers don't have to deal with the federal act. However, depending on what state you're in, you've got to deal with state issues, and the state laws are very different than federal laws.
And one more thing, I know my company had independent contractors. Are there any laws? There's really, that's just completely.
No, it's not completely, but it's dangerous.
It's more, okay.
Realize that the government would like you to treat everybody as an employee, because if you're not an employee, you're not entitled to certain benefits that employees receive.
Right.
So that's not to say you can't work with independent contractors, but you should be pretty judicious as to who you're working with, and make sure that they're truly independent. Do they have other customers or other clients that they're seeing? Right. All that becomes part of it, and always have a written agreement with them.
Oh, always. Yeah, it's very important, and I learned that. I mean, that's my next question.
Okay. The law is also, by the way, changing. There is some consideration going on now as to the treatment of independent contractors, and I think it'll become more difficult.
Well, yeah, for a small company, it's very hard to have, you're dealing with it. I know I understand both.
It is hard, but it is dangerous.
It can be, correct.
It can be dangerous.
Okay, so let's talk about the sprout phase for new business evaluating employee hiring. Okay.
So, there's a bunch of issues in terms of new employee hiring.
Okay.
And the first is to make sure you write a job description. And I know this is a very hard and challenging, and most small businesses are so short on time, the owners, because they're doing everything. But having a job description does a couple of things. First of all, it makes you focus on what you're really looking for.
Right.
Secondly, you want to specify in that job description what those essential functions are that this person's going to be doing. And part of that comes because as soon as you hit the statutes in terms of 15 employees, for instance, would make you subject to the Americans with Disabilities Act. So as soon as you hit that, you need to worry about somebody needing an accommodation. So the essential functions of the job play into that, and that could be everything, including attendance, showing up on time. If they're a receptionist, that they've got to be there regularly, they've got to be on time.
But wouldn't the person rather know that this employee that they're hiring is very clear, everything's transparent, so you want them to retain them. You don't want to do this again and keep hiring. It's
funny
exhausting.
You should say that.
It's exhausting.
So a couple of things.
Yes.
One, yes, you want them to know what's expected of them, but you still want to put a little bit of wishy-washy language at the end of that job description so that you can ask them to do things that you didn't think of before but might fit that same job responsibility. Secondly, there's been this concept that as long as I can remember called hire slow, fire fast. And, there's a good part to that and there's a bad part to that.
Right.
So the good part to it, frankly, is you want to make sure you've gotten the right person if you're going to hire. Does that person really have the qualifications? Have you spent the time figuring that out? Do you need to do a background check? Maybe, maybe not, but that has all kinds of other issues attached to it that you have to comply with. But let's assume you found the person that you think is the perfect individual, and you've now hired them. Do a little bit of background search, at least call some former employers. Don't just blindly hire somebody. That'll help you for a negligent hiring issue, and it's a good practice.
Oh, absolutely.
So make sure you do some reference checking. So now you've hired this individual, and they're not exactly what you thought they were going to be, So now the question becomes, are the issues ones that you can counsel and manage, or is this person just the wrong person? counseling and managing the person is not a bad thing to do. It's actually a good thing to do, because just realize how hard it was to find the person in the first place.
Right.
But in the same light, if it's not the right person, cut them loose.
It's like a relationship. I mean, honestly, look at how many times you date somebody, and in the beginning phase, everything's great, and then it changes. It's very important. You really never know someone until you really, I want to say live with them, but you're actually,
well, it is. You are living with them.
You're cohabitating in a area for every day, more than they are with their wives or husbands.
That's true. You're spending a lot of time with that individual, but there's the courtship, and then there's the marriage.
Yes.
But the issue is, just like a bad marriage, you need to get out of it. In this case, you do too. And I will tell you.
Right.
I'm sure you've all heard the comment, "No good deed goes unpunished." And I will tell you, I use that phrase much more than I wish I had to. And the reason being that many employers that come to me and are having a problem with their employee, oftentimes they don't come until it's kind of late, meaning they filed an EEOC charge, meaning that they've now asking for some kind of a medical accommodation, wanting to file FMLA, all of those issues. And it's like, I should have fired them 2 weeks ago, 3 weeks ago, a month ago, when I knew that they weren't performing and that they were going to be a problem. But I didn't have anybody else, so I kept them. And that's not a good thing to do.
Okay. Gosh, very elaborate. I love this. Very good elaborating about these issues. Okay, let me see. So let me ask you one thing. Okay, so some questions we talked about. Am I ready to hire? Who should I hire first? Can I afford to hire? What steps should I take? So we kind of touched a lot of them. That.
But when we're hiring, we also have to be prepared to fire. So please evaluate your employees. You may see, if you go online and you Google hiring people, they're going to tell you to put them in a probationary period. We don't use that term any longer.
I was going to ask you that.
Because the word probation kind of is somebody who's done something wrong, and now you're, I think of it almost like a criminal probation. What you want to do is put them on an introductory period where
that's
they
can
better word, right?
Better word.
So or a training period where they can evaluate
someone who feels that they're on this period that they're going to be watched and they could be fired any chance. They can't really excel and show their true potential because they feel like they're walking on eggshells.
Well, it's interesting you said could be fired at any time, and I'm going to tell you, you need to keep everybody as employees at will, especially early on. You don't want to hire anybody and give them a 1-year employment agreement, or you don't want to give them, a term of an employment. Some people kind of mix the term along with a termination at will, and that's fine. Make sure you get advice regarding that, but you want to be able to terminate anybody at any time for any reason, with or without cause. And some states don't allow that. If you're out in California, you have my sympathy, only because California employment laws are very hard to deal with and are very specific. And there are a few other states that are like that: Illinois, Massachusetts, New York. Some of them make it very hard to get rid of even a bad employee. So just be careful, know your state law, get good legal advice. One other thing I want to mention, because I think it's really important: categorizing somebody as a salaried employee versus an hourly employee. Many people like to be thought of as a salaried employee because it makes them feel more important, right? I'm going to get the salary every week, and that's because this is an executive assistant. Well, that executive assistant may really not be a salaried employee under the law. The law basically is everybody is an hourly employee unless they're not. And the not is a very limited set of exemptions, including that you've got to pay somebody a set salary every week regardless of the quality or quantity of work. And if they show up and they leave midday, you're still got to pay for that whole day. So you can't, it's a weekly salary for the most part. Right now, I think it's $684, $686, something like that per week. I don't have the exact number. It is going to be going up. There's going to be some changes in it. We've been watching and waiting for the Department of Labor. They haven't advised us yet. But salary's very different, very limited, and be careful because that's where you get caught. Don't let people work off the clock that are hourly employees. Even if they say, oh, I just want to sit in here and get this done. I don't want to go home without it done. If you allow them to do that, you have to pay them for that time. So one story, I had a client, the employee would get a ride in every day with her husband. She needed to come in before her shift started. She was an hourly employee. Don't worry, I have to be here. I'm just gonna sit in the coffee room. Wow. I'm just gonna sit at my desk and clean up my desk. Well, fast forward, she ended up getting terminated. And the termination was not a bad termination. It was for a good reason. But she came out of the woodwork with a little booklet that showed that every day what time she came in and what time she left. And now all of a sudden you've got a wage and hour lawsuit. And there are a lot of plaintiffs' lawyers out there that love those because you lose by $1, you're paying their legal fees.
Oh my goodness. Okay. No,
Sorry.
thank you for no, that's a great tip. No, honestly, people need to know this and it's very important. And I so appreciate your time right now talking about business wellness today. Diane does work at Fox and Rothschild.
It's Fox Rothschild.
Fox
No and.
Rothschild.
Fox Rothschild.
And she can be reached at www.foxandrothschild.
No, foxrothschild.com.
See, I need to put my glasses on. This is a misspell. Sorry.
Oh, okay. It's
foxrothschild.com.
Don't forget the S in Roths.
And it's in the Palm Beach, at the Palm Beach office.
I'm in the West Palm Beach office.
And we will put her email in the description box below. All right. So thank you, Diane, for collaborating with our channel today. And our next segment will be about startup companies' legal housekeeping items. All right.
Sounds good.
Sounds good. We'll do that. Sounding off from Boca Raton, Florida. Thanks again, Diane.
Bye.
We'll be right back.
Bye.